Hello everyone, today's video is about actus reus conduct and circumstances. What does the actus reus consist of? The actus reus in a crime comprises conduct and circumstances necessary to render that conduct wrongful if any are required, results if any is required. In this chapter we will concentrate on the conduct and circumstances elements of actus reus. Conduct the act requirement. The core element of criminal liability is some form of prohibited conduct. Usually this prohibited conduct will involve a wrongful act. Identifying an act is therefore a key task for the prosecution. Although there are expectations generally, if the defendant has no acted, there can be no liability. This principle is known as the act requirement. What is an act? There are two components to acts. The first is the bodily movement, American Model Penal Code. The second is that the bodily movement be voluntary. A bodily movement. Taking murder as an example, the conduct element in murder consists of any act that causes the death of a human being. The prosecution must identify and prove that such an act took place. There is no need for an act of violence. Any act which causes death will do. Poisoning the victim's drink is an act. Cutting the brake cables of the victim's car is an act. In Howard 1908 21 Cox C 692, it was sufficient that the accused threatened and chased his victim, who consequently died of a heart attack. The corollary of this is that if as contributing to the occurrence of a criminal harm can be described only as doing nothing or not lifting a finger, she cannot be held criminally accountable for that harm. Am I able to identify the act component in an actus reus? To decide either D has committed the actus reus of a crime, you need to find the definition of the crime, distill from that definition the actus reus, identify from that actus reus the act of defendant which you are to rely on and establishing that actus reus. This is not always easy. Exceptions to the act requirement. There are some expectations to the usual rule that criminal wrongdoing actus reus requires an act. Certain crimes do not require any act at all. These include what are termed situational crimes, crimes of possession and crimes of omission. Situational crimes, crimes of possession and crimes of omission. Although the conduct element in crimes generally is an act, there are some exceptions. Criminal liability is often based upon a failure to act as the law requires, as in failing to wear a seat belt, failing to tax one's car, failing to submit a tax return, or failing to display a license plate. Such offences are typically statutory strict liability offences designed to regulate behavior rather than punish moral wrongdoing. They are known as statutory crimes of omission. Criminal liability may also on occasion be based upon being in possession of prohibited article, for example controlled drugs, extreme pornography, offensive weapons, articles for use in terrorist offences. These again are statutory crimes and are known as crimes of possession. The final exception is what is termed situational liability. The prohibition for these offences is not some form of act, but similar to the other two exceptions, simply being in a prohibited situation. For example, it is a crime to be drunk in a public place, or to be drunk in charge of a vehicle, or to be the owner of certain types of dangerous dogs such as pit bull terrier, or to allow a dog to be dangerously out of control in a public place. The problem posed by both possession offences and situational liability is that criminal liability does not depend upon the defendant having chosen to be in possession or be in the prohibited situation. In other words, no wrongdoing is required. The offence in the case of owning a pit bull terrier is constituted although the dog was by way of unsolicited gift, and although the defendant believed the dog to be of another breed. The offence in the case of the out of control dog is constituted although the defendant performed no act and took reasonable steps to keep the dog under control. In relation to crimes of possession, a person can be guilty of being in possession of a dangerous weapon when they believed the article in the possession was, for example, a torch and not, as it subsequently transpired, a taser. Omissions and commissions. We have seen how failure to act may serve as the actus reus of an offence where the defendant is placed under a statutory duty to act as the statute requires. They are known as a criminal omission. This is an exception to the act requirement in criminal law. However, since the behavior demanded by the statute is clearly specified and is not onerous in its demands, it is not contrary to principle. A more controversial exception to the act requirement concerns crimes of commission. Can these be committed by omission? Crimes and commissions are those crimes whose definition includes an actus reus which satisfies the act requirement but whose result component can be caused by doing nothing. For example, the actus reus of murder is an unlawful killing. Dictionaries define kill as an act of killing but also define it simply as causing death. An act of killing involves some affirmative action such as stabbing, shooting, beating, poisoning, and suffocating, and so on, but it is possible to cause death by doing nothing. For example, it is a perfectly correct use of language to say that a parent who gives her baby no food so that it dies causes the death of the child and indeed kills the child. The controversy concerns how far this principle should stretch. Only one person can pull a trigger, but every passerby who sees a baby drowning in a puddle but does nothing to help can be said to cause the baby's death. Are they all to be charged with murder? How do we ensure that only the truly deserving suffer conviction and punishment? Key requirements for criminal liability. To ensure the net of criminal responsibility is not spread too far, there are certain key restrictions on criminal liability for crimes of commission in cases of harm caused by omission. The conduct element of the crime in question must be capable of commission by omission. 2. The circumstances must be such as to create a legal duty to act. 3. The defendant's failure to act must be in breach of that duty. 4. The defendant's failure to act must be voluntary. 5. The harm must be caused by the omission. The conduct element of the crime in question must be capable of commission by omission. Most result crimes can be committed by omission. This includes theft, murder, criminal damage, fraud, and most forms of manslaughter. Some, however, cannot. The definition of some offences specify or imply that only acts are sufficient. Assault is one. D was charged with indecent assault. What he had done was to cause a 15-year-old girl to masturbate him. The Court of Appeal held that the offence was not made out. Indecent assault requires there to be an assault. An assault requires some form of act on D's part. Here the act was the girl's, not his. D had committed an offence but not this one. This offence was causing a child to engage in sexual activity. Harm must be caused by the omission. The prosecution must be able to prove that the defendant's breach of duty caused the harm. A parent failed a call for medical support for his ailing child. The child subsequently died of smallpox. The parent was convicted of manslaughter at first instance, but the court for Crown cases allowed the appeal since the prosecutions could not prove that prompt medical attention would have saved the child. But put another way, the prosecution could not prove that the defendant's failure to perform his duty had caused the infant's death, since the child might have died anyway. For more information, what must be proved to show that the prohibited harm was caused by the accused acts or omission, see Chapter 4. Thanks for watching.